Like and subscribe right now, or else this will be in your bed tonight. r/AskReddit by Planet Reddit. Lawyers of Reddit. What is a detail that your client failed to bring up to you that completely lost you the case? Opposing counsel. Isn't it true you hit victim in the face with a brick? Client. No. Marcus hit him with a brick. I hit him in the back with a piece of wood. He sent a photo of his wife's beating face to his wife with a message saying something along the lines of this: "Do you want this to happen again?" He came across very well and caught up to that point, but his mask slipped when that came out. Lawyer in the UK. I acted for a member of a famous paedophile hunting group. My client was charged with various offences relating to his vigilantism. Most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Edit. Spelling. Edit 2. Spelling again. There can be only one. I beat up pedophiles in my spare time. No one will suspect a thing. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an AC at her. This is bullshit." Judge rescinded plea deal because of defendant's attitude, lack of remorse. Went to trial and got a year in jail. The idea of having an AC unit thrown at me is honestly terrifying. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. So you're saying it's just a prank? Bro. Isn't a valid legal defense? Not since Prankster v. Bro in 1986. Case as a paralegal. Negligence case. Client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Your Honor, if the cable repairman had simply fixed the cable in accordance with professional standard practices, my client would have had no other recourse but to keep his ostrich in the corral on the evening in question. A buddy of mine case as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I'm a court-appointed attorney for qualifying individuals and family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, We have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope. All good. Let's get my kids. Great. That's not happening today. But let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working. 2. No longer in apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back. And is 4 months pregnant. All in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. We became a foster family about a year ago. We've had several short-term placements since then, and I always go to the hearings because that's when you can truly find out what's going on. Kid is put into care with all kinds of injuries that parent can't explain, but they all seem to happen when they're at work and the kid is left at home with family. It was very clear that the kiddo was being abused and neglected during these times, and their romantic partner was the only one there when these injuries were happening. The parent comes to court and lets us know that they've broken up with that person and we can give them their kid back now. Judge asks when they broke up and parent replies, "Just now before we walked in so I can get my kid back." Abusive person sitting next to them. Drove them there. Still living together. Etc. Judge wasn't buying it. A relative told me about a case where the mom's boyfriend she met through a wrestling chat room, this was in the 90s, murdered one of her kids. Police couldn't prove it, so he was never charged, but everyone knew he did it. So when mom comes to court to try to reunite with the kid who wasn't murdered by her boyfriend, guess who was sitting next to her the whole time? Yeah, she didn't get that kid back. Minor traffic cases can be the worst for this. Believe it or not. Because they are short and simple, and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case. 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the others cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did claim she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class. And she should probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing. And so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. And he picked the card up and read it. I was expecting he easily walked up or sat down. Not that he was stupid enough to actually read something out. I love reading through this thread at all the stories and thinking which of them, if they wrote them into a television show, would be laughed off the air as too ridiculously made up. This one is a prime example. Lol. I'm a public defender in an area with lots of meth use. Meth makes most people talk. A lot. So I can't tell you how many clients forget to mention that they got to the jail still high and called their mom girlfriend buddy on the recorded jail phone and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. Edit. I'm seeing this question a lot, so I'll add some info here. This is not legal advice. Just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded. Depending on the facility, calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. I was in court once for a school journalism project and there was a woman in court who had been arrested for weed and crack possession when she came to bail out her boyfriend from a separate arrest. Apparently he called her from jail and told her to come bail her out and to bring some weed and crack. The guard overheard him and it was recorded on the jail phone, so they arrested her when she showed up. I want to think these people are just addled by drugs, but somehow that feels like wishful thinking. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together. And instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Edit. Yes. In some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. What would be the benefit of this though? Did they give a reason? Like, why would they be content to continue with a divorce case if they were no longer getting divorced? I could see an argument for a couple who wanted to get divorced and separate their assets, etc. to try and relieve some of the pressure that can be put on a relationship by that kind of stuff. So they no longer want to be married and want to take their relationship back to a lesser status without joint assets. Of course, there's probably a much easier way to do that. Credit card theft fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him and I learned that day to better prepare my clients for trial. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown A, and the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. I can't get the file to play. What is it? Video of the incident. Oh. It'll show you didn't do it. Right? Oh, yeah. Great. Next file please. Man. This lawyer gig is EZ. Little late to the party, but here goes. And obligatory not my client. company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company. Friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways and each time the COO denied any out of work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him he said, "But I never had contact with her. It's not like I delivered the flowers myself." Thanks for watching. Subscribe for 3 videos a day.